about the harm. The first thing to remember about it is the issue is whether or not it is a cause and fact. Don't get into saying, was the defendant the cause of the accident? That's never the standard. There can be 10 people who are the cause of it. It's not going to let your client off if your client was a cause of the harm. And you are a cause of the harm if your breach was a substantial factor in bringing about the harm. That's the standard for cause and fact. Now, if it's arguable, how do you decide it? You've got a lifeguard. The lifeguard is at the beach. The lifeguard decides to go across the street and have a few beers in the bar. While the lifeguard's gone, someone drowns. Is the lifeguard negligent? Yeah, there's some probability of harm if you leave your lifeguard position on a busy day with a lot of people swimming. The harm could be very grave, and no great burden on waiting until you're off your shift before you go get a beer. So you're negligent. Is your negligence the cause and fact of the drowning? Who knows? People drown even when lifeguards are on duty. But the courts have adopted an approach for these kinds of situations. It's in the Reynolds v. Texas Railroad situation. They ask themselves, is your conduct of a character that leads naturally to this kind of harm? If it's, does it greatly increases the chances of this kind of harm occurring? Well, if it greatly increases the chances of this kind of harm occurring, and it's of a character that naturally leads to these kinds of harms, the court's going to say, we'll leave it to the jury. If they decide cause and fact, we'll accept that. So a way of being persuasive in situations where it's uncertain is ask yourself whether it increases the chances of this kind of harm occurring. Ask yourself, is it of a character that naturally leads to these kinds of harms? If you can answer or persuade people of both of those, then you've got cause and fact. Then you've got, it was a substantial factor. Ordinarily, cause is not where it's not an issue, you just say but for. Use the but for test. But for the breach would the harm have occurred. But for is informing you that if you take this, if you agree to take these pills the doctor's prescribing, if he told you there's a high risk of blindness and he failed to tell you that, is his failure to tell you that lead to your becoming blind? If it did, you got cause and fact. But for test works. You're saying, had I been told, I would have never accepted the treatment. But for his failure to inform me of the risk, I would not have accepted, I would not have consented, and therefore I would not have lost my sight. So the but-for test is what you start with. But for the breach. The biggest mistake students make is they say, was the conduct of the defendant a cause and fact of the harm? And always the conduct is a cause and fact of the harm. That's not the issue. The issue is the breach. Whatever you argued was breach. The Perkins Railroad case. They were going too fast coming up to an intersection. The railroad engineer, the people in the engine thing. They conceded they were negligent. But was their negligence a cause and fact of hitting the car, or would they have hit it anyway at 25 miles an hour, the reasonable speed? If they were going to hit it anyway, then the extra speed was not a cause and fact. Their conduct was a cause of the harm, because had they not been operating the train, it wouldn't have hit the car. The issue is, was the extra 10 miles an hour a substantial factor? If it was going to happen anyway at the lower speed, then it's not a substantial factor. So use the but-for test in deciding whether it's a substantial factor. If but-for is not clear, move on to those phrases the restatement used that you see in the Reynolds case. Does it increase the chances of this harm occurring? Is it of a character that leads to this kind of harm? Then we're going to conclude it was a substantial factor in bringing about the harm. We'll leave it at that. But read everything there is under cause and fact. When do the courts shift the burden of proof on cause and fact? In very limited medical situations, but you should know that. So read the cause and fact thing and then see how well you can do with the practice questions. If I'm not back by then. I'll be back the week after if I'm not by then. So good luck with it.